most enjoyable conference. In this session, we're going to discuss the relationship between, I guess, philosophy and policy. We've already seen that philosophy of education has a great interest in the practice of education, and this is one further dimension of it, namely the relationship to policy. And I'd like to call, first of all, on Sudhir Krishnaswamy to talk about the Right to Education Act in India that was established in 2009.
I think this is on now, yeah. Thank you, Professor Hinchcliffe. So the person who introduced our panel and our session this afternoon luckily referred to the previous title that I had circulated, which was just very broad, and said that this would be about the RTE. Because in the revised abstract and title that I sent out, I suggested I would try and respond to three ideas in the RTE: autonomy, perfectionism, and paternalism. As things turned out, and as I waded through these issues, I couldn't get as far as the paternalism problem, for sure. I just left that out entirely. But today I will say something about autonomy and perfectionism in the RTE. Now, I must say a little bit about how I come to this presentation and this conference, and I've unfortunately missed so much of what's happened that I think it bears telling that I'm by no stretch an education expert or anyone who specializes in the philosophy of education. I'm a lawyer by training, and I do law and political theory. My interest in this field is in the legal issues that have in some ways anchored and shaped the development of the right to education in the last half decade. And I have a particular interest, at least in this paper, to try and explore some of the philosophical questions that underlie these legal challenges. So that's what I'm going to use this opportunity for. So I come really as a lawyer and someone who's interested in political theory and political philosophy, and try to address and respond to some of the concerns in the philosophy of education. So let me begin by how I went about that exploration and what I found. So I began with some looking at some of the I don't know whether to say leading or anchor texts in an Anglo-American tradition of thinking about the philosophy of education, particularly thinking about the problem of authority in education. And let me start with Amy Gutman as one example of this engagement. So Gutman in her book Democratic Education pays a lot of attention to the questions of education authorities, and I'll just use that as a sort of caption term. And she's concerned deeply about whether education authorities must rest with individuals, the individuals in this case being those who are educated. Should they rest with teachers? Should they rest with groups of teachers, maybe teacher unions, maybe school societies, which may or may not include parents, bureaucrats, or political authorities, just per se, might be a departmental authority or a minister. She frames that engagement through four frames, and I'm not going to take you through that in detail. I'm sure many of you here are more familiar with this than I am, talking about the state of families and so on and so forth. She essentially leads in that introductory section to her book to the argument as to why a democratic education is arguably the best form of thinking about the problem of authority in education. What's striking in the way the book is set up and framed is that the primary contestants over the problem of authority are individuals and families on the one count, political authorities on the other, and the state. And I'm saying political authority, I'm just distinguishing between political authorities more generically and the state to highlight that there are various levels of boards and councils that sit between the family and the individuals and the political authorities and the state. So there are a range of political authorities there. What's striking in that the area of authorities on which the debate is centered is the absence of private educators or the market. And Professor Hinchcliffe, in a more recent piece published in 2014, similarly maps out the problems of educational authority and considers a range of actors, but significantly private actors are absent from that range as potential claimants to educational authority. And what struck me in my very early introduction to the problems of the philosophy of education is that, at least in the Anglo-American tradition, and I'm by no means familiar with all of it, or for that matter with other traditions of thinking about the problem, private actors are either entirely absent or certainly not significant enough to be placed at the center of the problem of authority in education. Now, let me shift from there. And so when I saw this literature and I looked at the way the problem was set up, it alerted me to how stark a difference the Indian both political and constitutional position on education is. And that's what I want to turn to. But before I say that, I don't want to suggest for a moment that I don't draw on any of these sources, whether it's Gutman or Hinchcliffe, because I'll come back at a later point to suggest that maybe we should pay attention to these materials in the way we think about the peculiar institutional and political problems we face in thinking about education in India. Okay, so let me shift tack and say a little bit about what's happening on legal and constitutional argument around education in India. So most of you are familiar with the Right to Education Act, which came into force in 2009. It's the key central statute. There are several other state statutes which governs this field, and it seeks as a matter of objective to provide free and compulsory education to all children of the age of 6 to 14 years. And I'm sure that many of you in this room are also familiar that this emerged out of a constitutional amendment, Article 21A, which gave the state authority to make such laws. Article 21A restates in slightly different terms the same objective: free and compulsory education to children from the age of 6 to 14. This statutory right, the statutory framing of the right to education, has various components. It imposes obligations on a range of actors, and it just bears paying some attention to the range of obligations it imposes. First, on children themselves to be present in school. Second, on parents to ensure that their children attend school. Third, on schools to organize and deliver education in a particular form. And fourth, on the state to compulsorily provide for education, both as a budgetary and administrative matter. So 4 kinds of obligations, legal obligations created by the statute, all of which pose different problems of authority, right? So some of the concerns in the Gutman, I just say Gutman Hinchcliffe as a sort of model, and maybe there are others. In that kind of concerns of philosophy arise here. There are issues of compulsory education. There are issues of parental obligation. And there are issues of the role of the state in the delivery of education, so state authority. What is striking, though, in the Indian context is where legal challenges have emerged from. And it's not, and I'm not suggesting it's accidental, but it's worth paying careful attention to, as to where have the legal and political challenges to the statute and the nature of educational authority emerged from. It hasn't emerged from children or children's groups, unlikely litigating category in any event, but it hasn't emerged from parents either. So we haven't seen a cultural objection to compulsory education of any sort yet, at least on a national or certainly not aggregated to a legal challenge. That may still come, but it hasn't come. So where has the challenge come from? It hasn't come from either other sort of disparate community or ethnic groups, religious groups. So the challenges to the range of obligations imposed by the RTE Act have come from one sector, the private school sector. So, and I'll just draw your attention to two challenges which are significant. There are other challenges to the right to education, but it's worth paying attention to these two challenges, the most serious ones in the Supreme Court. In a stylized sense, the two cases, I'll just call them the Societies case, which is the early two-judge bench case, and the more recent Pramati case, which is a five-judge bench case, which is less than a month old. In a stylized sense, they raise three sorts of arguments. First, they argue that the state, by passing a statute of the right to education sort, imposes obligations of two varieties on private actors, both of which are unjustifiable. Private actors here, we're talking about educational authority, meaning private actors are not students, they're schools, right? They're schools which contest the authority of the state to define the contours of education, private schools. So, and the two sorts of obligations that have been particularly opposed to are the obligations relating to reserving a quota, a reservation obligation in schools, so controlling the kinds of students they admit. And second, a range, I'll just call this a general regulatory obligation, which is a range of obligations relating to the way the school is designed, what infrastructure it provides, and all of that. So I'll just hold those details apart. I think in a philosophical argument, I can be scant with those details. So the general regulatory obligation and the reservation obligation are challenged by private schools as going far beyond the mandate of the state in the field of education, and second, as violations of their fundamental rights to organize, in this case, for want of a better phrase in Article 19(1)(g), a business. That they have a right to organize a business, and in this case, in the context of schools, but that the kinds of regulations in the Act or emerging from the Constitution impinge on those freedoms. So there is an autonomy concern, but it's not about the autonomy of individuals who are subjects of the education project. It's about the autonomy concerns of actors, in this case organizations, schools, which are in the project of delivering education. So it is a contest of educational authority, but a contest of a very different sort. Now, the third strand of argument that emerges in the Indian debates is should be taken seriously, but not too seriously, and I'll just suggest why. The third strand is to suggest that minority institutions of a linguistic or religious sort should have an even greater domain of autonomy protected against state authority in the field of education. Now, this emerges from some doctrinal aspects of the Indian Constitution and a history of interpretation. But if I keep that aside, while it is phrased as a minority argument, it is not phrased as a cultural argument. There's in no part of the argumentation in the court is it suggested that what's really at stake with respect to the autonomy of minorities is their cultural specificities, either about the content of education or the mode of delivery of education. They're only claiming a general exemption from the general regulatory clauses and from the reservation obligation that all other minority actors are subject to. So we should not overemphasize the minority argument in the Indian context as some special kind of cultural argument for autonomy. And there is a considerable debate, I know, in the philosophy of education about cultural autonomy. So in the Indian context, though it takes that rubric as a matter of constitutional doctrine, it's not really that as a matter of, as a key political question. What does the court do when it's confronted with such challenges to the educational authority of the state? The court responds in two ways. First, it tries to create exceptions and limitations to the fundamental right to education, and exceptions and limitations to the rights to do business. So that is a doctrinal matter, but substantively, what the court is engaged in is to try and limit the scope of the right in some ways, to say that, that you have a right to run a business, but it does not include an unfettered right to run a business in the area of school education. Or the court might say something like, you have a right to do business, but it may be limited by the state's right to regulate in the field of safety, or some such thing. So what you get is a fettering of a broad right, and the question is posed as a core conflict of rights, two liberal constitutional rights at conflict. And what can courts do? They create some sort of exception or limitation. The other strategy that the courts have adopted in the context of minority rights is to talk the language of balancing, and to suggest that what we can do in these contexts is to somehow balance the interests of the minorities by giving them a greater greater authority in the field of education, but limiting it in some modest respects. So the language of balancing and the language of exceptions and limitations have come to be central to the decision making in the Supreme Court in these cases. What is striking in these cases is that the court makes no distinction between the relative weight either of the rights. So there's no ordinal ranking of rights. The right to education stands in coordinate status to the minority right or to the right to do business. First. And second, there is no ranking of the educational authority at stake. The court has no sense of hierarchy that the educational authority of the state in the context of school education may somehow be superior to the claims of a private organization of any type in the same field. That kind of inquiry and that kind of question is a question that the courts have completely avoided up to this stage. So how do we make some sense of this contest, and how do we draw on the existing debates on the philosophy of education and elsewhere in a philosophical sense to shape and mold the legal arguments in the Indian context? So this is the tack that I'm going to take in what I see, at least in my sense, as the third part of this paper. If conventional concerns in the philosophy of education have not centered around the role of private educational authorities, and the Indian debates do center around this, I'm going to propose that we can learn from some debates on educational authority to get around the unfortunate situation that we find ourselves in the Indian context. So, and let me sketch this in two parts, and I'll suggest that Professor Hinchcliffe's idea of a republican liberty is a good way to start. And second, I'm going to suggest that this need not be a perfectionist account of the idea of education. So it need not be, in some sense, an endorsement of the state's capacity to frame our idea of the good in the field of education exclusively. And I'm going to try and sketch these two strands of the argument in my next 10 or 15 minutes. So if we phrase the question as a classic problem of a conflict of liberties or a conflict of rights in classical liberal theory, the position that we are left to articulate is how do we promote the maximum freedom of one with the least interference to the other. That's the classic position that our court tracks. It says there are multiple liberties at stake here, and in a liberal constitution, we must promote each liberty to the maximum extent that we can, and without erasing anyone else's liberty. That's the classic liberal conflict of rights problem. what was striking in the drafting of the Indian Constitution is that the right to education, it was not called a right to education, it was just called, the education directive principle, went back and forth between two chapters of the Constitution. It was initially proposed as a fundamental right to education. It was subsequently pushed into a chapter called the Directive Principles of State Policy, which is a chapter that holds a range of principles of social and economic justice, which are not justiciable, but are central to the practice of the state. That was its, that's exactly what Article 37 says, and that was the original intention behind having two chapters articulating the key goals of the Constitution. The idea behind Part 4 of the Constitution is to put in place a range of principles of political and economic justice that the framers of the Constitution saw to be essential for a liberal democratic order to take ordinary course, to give birth to a liberal democratic order. You must remember that when we're talking about a constitution drafted in India between 1947 and 1950, there was an acute awareness, right, at least from the periods of the 1920s, when the roundtable conferences between British administrators and Indian political representatives took place, that the conditions, the preconditions for a liberal democracy didn't exist in India. At least, I mean, there's a large literature on this. Mill says this as much in his tract on the conditions for a representative government. But Indian representatives at these conferences were always at pains to show that despite not having the preconditions for a liberal democracy, that liberal democracy would somehow bootstrap itself to produce these conditions. So a classic liberal account would be that we are completely anti-perfectionist about the good. We don't know what's good for this society, but what we do know is that we will give every individual who has who's entitled to that political voice, equal political voice. And then the determination of the good will take place in the normal conditions of liberal democracy. The framers of the Constitution were distinctly uncomfortable with this view. They were uncomfortable with this view because they knew that by any token, and they had been reminded, even if they didn't know for 30 years, that all the preconditions, the classic political theory preconditions for the existence of democracy, literacy, reasonable absence of economic hierarchy, some forms, the existence of a civil society with the absence of sharp social hierarchy, none of these were true. These were the stated preconditions, none of which were true. And so what they crafted in Part 4 of the Constitution was the idea that there would be these principles of political and economic justice, which were not complete specifications of the good, but articulated some core principles that were in both non-justiciable and non-derogable. And they saw this as and this was a peculiar and novel way of doing constitution drafting. They saw this as a method by which they could solve the problem of initiating democracy in India in 1950 and resolving the problem of preconditions. This is a peculiar sort of almost, it's in some senses an illogical, at least in a temporal sense, idea of the way the preconditions for democracy could be generated. All of these were placed in Part 4 of the Constitution. What drives Part 4 of the Constitution is, and this is subject of some other work that I'm writing, much larger than the concern with education in this talk. It's a concern with an idea of liberty that doesn't square too easily with the idea, a classic liberal idea of equality. So where else might you look? What other idea captures the political character of Part 4 of the Constitution? And I argue elsewhere that what captures Part 4 of the Constitution is a commitment to a republican liberty. The idea that non-domination, at least a certain form of republicanism, the non-domination strand of republicanism developed by Skinner, Pettit, and others specifies liberty as the absence of non-domination, both in the social and in the state sphere. And this is critical because in the education context, and I'll develop to what the upshot of this argument is with respect to the Indian education context. Notice here that there is a wider debate, and Professor Hinchcliffe works through this debate in his paper about the relationship between ideas of positive and negative liberty in Isaiah Berlin, in theories of liberalism, and what a republican liberty might mean. And I don't want to join that debate here, except to say that the idea of republican liberty allows us two crucial strands of argument that can come to play a critical role in shaping education in India. First is that it goes beyond the state to talk about the conditions in society, because non-domination, if it exists as a condition of liberty, ranking higher than the conditions of liberty. So what I'm trying to suggest here is that the other rights of the Constitution, the Part 3 fundamental rights of the Constitution, they sit in a different status, normative status, to the fundamental, to the directive principles of state policy, right? So you have principles of social and economic justice that are seen as, in some sense, priors for a liberal democratic society to fully function. This was certainly, and this is the burden of the longer work that I'm working on, the way that the framers of the Indian Constitution saw this project. That I'm pretty clear about. They saw this and they maybe naively assumed that this was a project that would take between 10 and 15 years. So many of the clauses, including the education clause in the directive principles, had a sunset. They said in 10 years you will achieve this, or in 15 years this will happen. It's another matter that the political history of India and the complexity of India has meant that this is not, it's a perpetual project. It's not a time-bound project. But the view that the framers advanced, and they placed education very carefully in that part of the Constitution, was that these were the priors on which a liberal democratic society can be built. And there are wider debates about whether these were exceptions to the rule of law and so on and so forth, which I'm dealing with elsewhere. But I just want to stop at this stage, at least for the purposes of this talk. What do we get by reconceptualizing the idea of an education right nested in a theoretical foundation closer to ideas of republican liberty than ideas of like a classic liberal constitutional right? What I would argue is that in the Indian context, we have two significant outcomes of this reconceptualization. The first is that we move away from the problem of the conflict of rights and the problem of a balancing of the right to education and the right to do business without paying any attention to the normative weight of these different rights. So long as they're in Part 3 of the Constitution, unless the court were to be able to articulate a political theory of the Constitution, it would not be able to organize these rights in any ordering of priority. By locating a right to education as a republican liberty of the sort that I argue, at least, that our Constitution suggests belongs in Part 4, what we get is a sense of the priors of a liberal democratic society. So the right to education must have, in the realization of the right to education must have a greater priority than all other rights that emerge out of, or that in some sense frame the rules of a liberal constitutional democracy. The second idea that I would I would suggest that we get by this reframing is that we move away from an obsession with the role of the state in education, and we can anticipate and develop an idea of the effect of this normative value on a range of actors, on a range of educational actors, in this case and in the Indian case, particularly private actors in the field of education, that they too would be subject to the need to realize, first and foremost, the basic mandates of schooling, which the Constitution sets up as being somehow prior to their otherwise expansive rights to do business in this field. So in these two ways, I would suggest that a Republican liberty-based conception of the place of education can do a lot of useful work in the Indian context, both constitutionally and legally, and more to shape the political discourse in this field. The last thing I want to close with is that we need not assume that by taking a Republican view of liberty, and in this case a Republican view of education, that we would end up with a sort of unhindered state authority to determine both the content and the modalities of the delivery of education. So we need not contend, or we need not face up to the prospect of some sort of perfectionist account of education as a good to dominate all other players. That is, that the state would dominate all other players in the field of education if we adopt such a view of education. And what and this is not an argument that I've sketched out in any detail, even in my notes, but my sense here is that we can take a Republican view of liberty which is not perfectionist in full. So we can take a Republican view of liberty that in the field of education that is anti-perfectionist. It does not specify all the aspects of the good, and can have a very narrow characterization about what the essential elements of the delivery of the right to education might be. It seems to me that while so much of the debate in the Anglo-American concerns with the philosophy of education deal with the content of education, the curriculum, and pedagogy, and all of these elements, what's striking about the constitutional debates in India, as well as the statutory content of the right to education in India, is that there's almost no attention paid to these aspects of the education project. So, and my sense is that's just as well. Because if it were to be in any other way, then we would have this problem that state authority would determine the educational project in all its extremities, and we don't need to imagine the project in that sense. So the way I would round that off is that I don't see that the Republican view of liberty, and in this case of education, poses any grave threat to other educational authorities in the way they might determine the content and the modalities of the delivery of education. So in this sense, I suppose that the view that I'm arguing towards is first that if we want to think philosophically about the problems of authority in the education context in India, we must expand the range of educational authorities we are concerned with. And as our experience over the last few years suggests, the primary concern must be with the role of private educational authority. And we must make some sense of where they fit in the authority grid. The second is that the Indian debate suggests that if we translate and if we place private educational authority at the same status and as enjoying equal rights to public educational authority, and simply see the task of both political discourse, political and philosophical discourse, and legal and constitutional discourse to simply reconcile, or reconcile conflicting rights, or to find ways to balance these competing claims to authority, then it's very unlikely that the project of basic education and schooling, compulsory schooling in India is going to take off. The only way we can do that, and what I'm suggesting, and my last sentence, is to reconceptualize the problem here as not being a conflict of rights, of equal rights, but to be one where we infused with the ideas of republican liberty, where we place education to enjoy a normative status as a sort of prior to the other contests in a liberal democratic society. So invest education with a normative, political normative weight, which would transform the present constitutional debates on this question. Thank you.
Thanks, Sudhir. I hadn't quite realised that someone at least has read a little bit of what I've written. We've got a great deal to discuss, I think, between us, but I think it's probably the best thing to open it up to the floor at this point anyway. So any questions? Do you want to take... I'll take 2 or 3 at a time. So
welcome, sir.
Sorry, I'll take 2 or 3 at a time.
So our Right to Get Education Act, last January 13 and 31, a conference, Think Education Conclave, conducted by Sastra University and Indian Express in Chennai, from Hamid Ansari to Karan Pedi also took part, and HRD Minister Pallam Raju, and Rakesh Mittal, Bharati Foundation chairman, also criticized RTE education. However, RTE Education Act did adopt no detention policy. This policy hit the education quality. What do you think about, sir? But another question, the taking the right to choose the medium of language by parents and the society, how can we, the RTE, ensure the right to get education of our children? Then another question.
No, sorry, you've had 2 questions.
Our children's,
I think that's enough.
Ability to understand and creative thinking are being paralyzed by unknown language as refusing children's inherent and innate language. Does the social justice does not social justice include choosing the medium of language?
Thank you so much. Can I have...
Thank you for the presentation, and excuse my question if I haven't understood in the right frame, but I have a deep concern when you say that the Republican liberty makes us move away from the obsession with the role of the state. And given the Indian context, and I'm placing this very much in the Indian context, where the market, I think, is extremely exploitative, and it is sort of, I wouldn't say playing into the demands of the parents, but rather abusing the demands of the parents. And it is in the name of, while trying to justify itself within the hangars of market, it is actually educationally it's unjustifiable. So I have deep concerns when you make a sweeping statement of that such a framing takes away with the obsession with the role of the state, especially in an Indian context, which is so fragmented.
Okay, thank you. Thank you. Can I have one more question? Yeah.
You'd mentioned the unfortunate situation of the RTE. I didn't quite understand what you considered unfortunate. or which aspect of the right to education that you consider unfortunate?
Can I? Yeah, this is okay. So the first three questions were broader questions about RTE and RTE policy, and I don't know if there are others in the room who deal with these questions, but it was not something that I addressed, at least today. Should there be an anti-detention policy, and what does Rakesh Mittal think? I really don't know. My view is that, I mean, there's nothing I said today that goes on this, turns on this question. So, but maybe I can say one thing about medium of instruction, that the medium of instruction debate is not about what parents and children want to be taught in. The debate is about what the state wants the medium of instruction to be, and its relationship with what maybe the private sector or other aspects of other education delivery organizations want the medium of instruction to be. So it's not, I would not phrase it as a sort of quashing of parent and child autonomy alone. There's a wider cultural politics to medium of instruction. So the second question was about Republican liberty. So one of the disadvantages of having just notes and not having a full paper is that your phrasing is much more, you ad-lib a bit. And so the question as to what did I say about the obsessive concern with the role of the state? I don't know. I mean, because I can't recollect exactly when I used that phrase. But what I can address is the substance of your question, which is that I don't think that, so in the present political discourse and legal discourse around the question, it's very clear that private actors and public actors in the field of education are equally placed. So they have no special claim. Neither of them have any special claim to both the content and the delivery of education. It's laissez-faire, because the court is quite comfortable to say that the private schools and the private market can decide how they want to organize the field of education, right? So that's as it is. What I was arguing for is the idea that the state can have not a full control over everything that passes in the field of education, but can have a core regulatory power that emerges from the constitutional priority to education. So I wasn't in any sense arguing for a watering down of the regulatory role of the state. I was suggesting, I was trying to craft an argument to support a basic role, regulatory role for the state in the field of education. So in that sense, I think we, at least on this question, we're on the same side. Now, again, the last question to me was, I said something about the RT was unfortunate, and again, I'm like, I don't know what I said was unfortunate. I mean, there are lots of things that someone could say would be unfortunate about the RT, but maybe the one thing that I'll use your question to emphasize is that the judgments of the last fortnight are certainly unfortunate, because what we have is we have a judicial and political discourse around in the field of education that has no normative commitment to the project of a basic education. And this is deeply unfortunate. Does RTE advance that project or diminish that project? I think there are many views on all of these things, and I don't feel the need to go there. But I think that one thing that's certainly unfortunate is the lack of commitment or the lack of understanding in key political institutions, including the court, of the relevance and the importance of a commitment to basic education.
Okay, thank you. Are there any other questions?
So my question is with regard to the Pramati judgment. And as you pointed out, I was trying to follow it in media, and it seems to me that the common arguments made for religious minority schools in the West and for them to retain minority status and get the exemptions and privileges accordingly, none of those arguments translate into our context in the sense that those arguments of preservation of community, the cultural, religious arguments are not made. At the same time, the only thing that seems to come up is that these are numerical minorities. And I mean, pardon me if this is a naive question, but even say the economically privileged is a numerical minority. I don't understand how that necessarily associates with vulnerability, which is what would accord something an exemption. So, I mean, since I can't fathom what this argument is, it seems to me a transparent sort of use of this as an instrument for commercial motives. I mean, it's also because of incomprehension. So I was wondering whether you could sort of like elaborate on this argument a little more.
Okay, thanks. Any further question? If I could take Heinz, please.
Yeah, just a piece of information first. There's that a couple of interesting U.S. Supreme Court rulings that could inform your discussion. One of them is Pierce versus Society of Sisters, where the Supreme Court ruled that compulsory public education could be attained by placement in a private school. And another one, I don't forget the name of the ruling, but where the Supreme Court ruled that Amish, religious beliefs could justify less than a full compulsory education period. The Amish wanted their kids out after 8 years of schooling, and they were granted that right. That's a piece of info. And then a point of debate. I think it might be helpful if you distinguish conceptually between the state need not dominate education at the administrative or the delivery level, but it certainly ought to dominate at the policy and regulatory level. If one accepts that, then you have to establish a system of inspections and a system of quality enforcement that the state organizes and imposes on private schools. I don't know what the situation in India is, but that would have to be worked out.
Okay, thanks. I'm going to exercise chair's privilege and ask a question, if that's all right. I'm not familiar with the Indian situation, and I hadn't realised that the RTE, in effect, gives you the authority to educate on a private basis. That's the case. What I was wondering is that my thinking about education authority is there needs to be a principle of subsidiarity as well. That it's not just a question of authority flowing from the centre, but the authority to educate needs to be distributed. And in that case, I'm not quite sure what authority, quite apart from any social or egalitarian arguments, but what authority private schools have to educate if the only authority they derive is from a single act passed at the centre.
So the first question was about minority schools, and I suppose you won't be the only one to be puzzled, because most people, I think there's something to the language of minority schools which suggests that there's something very important at stake in a political sense, and as you suggested, our intuition is that there's some cultural or religious or other significant minority interest that rests at the core of this minority rights claim. And when we look at the Amish schools case, or we look at various other schools cases around the world, that's usually how minority rights are posed. But in the Indian institutional environment, the minority right it's not to any minority, but it's not any numerical minority, it's only to religious and linguistic minorities. So there is a limitation. You must be a religious or linguistic minority, But beyond that, there is no assessment of marginality or threat. It's anyone who can show that they're religious or linguistic can claim the benefit. It's striking that in the way that the Constituent Assembly debates on this question were raised, they were always raised as arguments about preservation of cultural and religious identity, not as a regulatory business right. But the way they've come to be interpreted, first in the field of higher education. So higher education has blazed this path 20 years ago when the court gave the Manipal group and others minority status, which meant that they could run a business effectively. And now it seems that the court is doing the same in the sphere of school education, where they will carve out a field of relatively unregulated, sort of a regulatory arbitrage position for minority schools, and then the name of the game will be who can classify as minority. So I think that this is a serious problem, and it's obfuscated from public view because people think when they read the language of minority rights that there's something politically significant in that exception, but really it should be seen for what it is, which is a business exception. For the most part, I don't want to. There are a very small range of schools which would attract that tag in a serious constitutional and politically significant way, but that's not where the debates are focused at the moment. On the US Supreme Court, and it's useful to look at that literature. In fact, we cited Pierce in the first case, in the Society's case, and we used these materials. On the Amish question and minority rights, the Indian jurisprudence is so far away from the rest of the world that it's going to take something else to pull it back to some reasonable identification of who are minorities and why they need special rights. But I like the other suggestion as well, which is that we need to distinguish between the instrumentation, the delivery role in education, and the policy regulatory role in education. And this will help me actually talk about both questions. Is that the RTE says nothing about the delivery role. It does not authorize the private school sector. It does not deauthorize the private school sector. It's neutral on that question. What it does do is that it mandates the state to provide education. And it can do this in many different ways, and there's one way which is to use quotas in private schools, which is one way, and the court has upheld that. So the policy regulatory role of the state in that sense is there. It's there in the RTE, it's been upheld by the court. But the carve-outs, the exemption, the exceptions to this regulatory role are becoming wider and wider. And so there will be, I don't know what a reasonable estimate of the minority school sector in India, I suppose it would be somewhere between 10-15% of the overall sector, but I have no doubt that it would be huge and growing because of the carve-out. So that's one. So the last question was, in what sense can we think about private educational authority in the field of education? And that was my puzzle reading the philosophy of education literature. And as I said at the start, I'm coming to it freshly, and I was struck by how remote it is from this literature to even consider the possibility that private educational institutions have a special kind of educational authority. It's so remote to the literature that it's not even a part of the grid of the main writing in the field. But in India, in Indian political discourse, and in our legal and constitutional discourse, it is taken for granted that private educational institutions have unfettered authority in the field of education, and that it is an activity, a business like any other. So they do have to comply with the norms around recognition, but beyond that, they have a very wide swathe of authority. And there's a stark difference, it seems to me, in the way the theoretical thinking in this field is organized between India and elsewhere.
Okay, it's 5-3, and I think we need to stop now. So it's for an interesting talk, which leaves a lot more for discussion as well. So that's good.